3, 2, 1, start. Two paintings auctioned by the appellant company and purchased by two foreign nationals were seized by Archaeological Survey of India, as it found the same to be antique in nature. Full stop. A complaint was made to the CBI, which prima facie found the commission of offence under section 3 punishable under section 25 (1) of the Antiquities and Art Treasures Act, 1972, and registered an FIR on 29/1/2004 for offences punishable under section 120-B IPC and section 25 (1) read with section 3 of the Act, and after investigation filed charge sheet on 28/4/2004 against the appellants and the two foreign nationals. Full stop. Thereafter, the appellants filed writ petition number 16598 of 2004 in the High Court challenging the report of the Director General, ASI, and confiscation of the said two paintings under the Customs Act. Full stop. In the writ petition, neither the CBI was made a party nor was the FIR charge sheet challenged. Full stop. The writ petition was disposed of by a consent order dated 24/3/2005, directing the competent authority to pass a fresh order. Full stop. Again, writ petitions were filed seeking to quash the FIR mainly on the ground that the basis of the FIR, that is, the earlier report of the ASI, had been rendered redundant in view of the decision of the Division of the High Court. Full stop. The High Court dismissed the writ petition. Full stop. Aggrieved, the auctioneers filed the appeals. Full stop. Dismissing the appeals, the court, para. It is pertinent to note that in the instant writ petition, the relief prayed for is to quash the FIR and not the order passed by the trial court, refusing to discharge the appellants from the criminal case filed by CBI. Full stop. The writ petition is mainly based on the ground that the basis of the FIR, that is the earlier report of Archaeological Survey of India, has been rendered redundant in view of the decision rendered by the division bench of the High Court by order dated 24/3/2005. Full stop. There is no explanation whatsoever forthcoming from the appellants as to why they did not implead the CBI in writ petition and challenge the FIR, though they were aware of the same. Full stop, para. It cannot be said that the basis of the FIR does not survive in view of the judgment of Delhi High Court in writ petition of 2004. Full stop. The High Court mainly observed that in view of the consensus arrived at between the parties thereto, it will not be necessary for the parties to give effect to the earlier report and If a new report is passed, the earlier report will not be given effect to, full stop. The earlier report has not been set aside by the High Court and obviously to continue its operation, a new order is to be made by the Director General, ASI, which has not so far been passed, full stop. At any rate, all these pleas may be advanced, if at all, available to the appellants, in the pending criminal case, full stop. The observation made by the High Court that it will not be necessary for the parties to give effect to the earlier report binds only the parties to the proceedings and, admittedly, the CBI has not been impleaded as party respondent in that writ petition. Full stop para. The jurisdiction of the High Court under Article 226 to issue appropriate writs is extraordinary, equitable and discretionary, full stop. Prerogative writs mentioned therein may be issued only for doing substantial justice, full stop. No person is entitled to claim relief under Article 226 of the Constitution as a matter of course, full stop. The High Court rightly refused to exercise its discretion under Article 226 in favor of the appellants, full stop. On the facts and circumstances, this court is not inclined to exercise discretion under Article 136 of the Constitution of India to grant any relief to the appellants, full stop. It is evident from the record that after registration of the first information report, the CBI made detailed investigation in the matter and filed charge sheet for the offence punishable under section 25 within bracket 1 read with section 3 of the act, full stop. The trial court having taken cognizance of offences framed charges against all the concerned, full stop. The appellants have been filed discharge application before the trial court, full stop. It is not clear from the averments made in the writ petition as to the result of the said application, full stop. On the facts and in the circumstances and keeping in view the progress made in the case, it is not possible at this stage to quash the very first information report, full stop. The trial court can consider whether the paintings in question are antiquities as alleged, full stop.